Okay, so Mirza Hashem will try to work on a difficult topic tonight. That is the topic of a Jew going to civil court.
Does that mean against another Jew or a non-Jew?
Let's start with against another Jew, but that's a good question. We're gonna get to that. Mirza Hashem.
Count against non-Jew will agree to a din Torah.
That's a great point.
See.
That's a great point. We'll get to that.
I think that doesn't mean you can't serve on a jury.
Right.
Because I've been called to jury, you didn't have to show up twice.
That's correct. We'll knock that off right off at the beginning.
Some thought if I ignored the order to appear, I would have been called Hashem.
Before we even talk about what the prohibition is, we'll already say what you're saying, that going to be on a jury is not included in the prohibition that we're about to mention. There is a prohibition that is alluded to in the pasuk at the beginning of Parshas Mishpatim. Asher tasem lifneihem.
My brother's promise center, and that of it, the second of his 5 sons.
So, as Chaim said, it says lifneihem. These are the laws placed before you, or you should place before them. Chazal darshan, the lolif, meaning it should be in front of dayanim, judges, who are wise men of Torah, chachamim, who are capable of paskening based on the Jewish law. And Chazal say, the sages say, that this is coming to the exclusion of 2 things. Lo lifnei had yoitos, not in front of commoners, meaning Jewish dayanim who are not experts in law. At the earlier time, it was that they had to be ordained, back from a connection going back to Moshe Rabbeinu. But nowadays, at least that they have to be chachamim. They have to be those that are familiar and experts in law, that are able to judge cases properly according to Jewish law. And the second thing it says is that not in front of the arkaos shel akum. It can't be in front of the non-Jewish, the court of the idolaters. A Jew is not allowed. We learn out from this drasha that a Jew is not allowed. There is a prohibition not to go to a non-Jewish court. This is what's called the lav haba michlal aseh, which is an interesting type of a violation. The Torah didn't write it in the form of a typical negative transgression, do not do, but rather said do this, which implied don't do something else. That's called the lav haba michlal aseh. It's a negative transgression, a transgression of the Torah telling you something not to do, which is implied from something that the Torah tells you to do. Go to the Jewish court, implying do not go to the non-Jewish court. Now, what are the possible reasons? What would be the possible problems of going to a non-Jewish court? Now, the first, most basic problem is that the Torah has laws of mishpat, laws of monetary laws of how cases are supposed to be judged. Lots and lots of detail. We have a whole, all Masechtas on monetary law. We have a whole choshen mishpat, a whole section Shulchan Aruch, with a very, very extensive system of law that is a divine, God-given system of law. And in order to judge using those laws, the person has to be well-versed. So the first most basic problem is that if you were to go to a non-Jewish court, they're not going to be judging in accordance with Torah law. They're going to be judging in accordance of civil law, which is the most basic issue. However, Rashi brings down on that pasuk. We have that even if they are danu and dina Yisrael, even if b'dinayim, even if you know that the particular issue that you are litigating is something which they have, their law says the same thing that Torah law says. Nevertheless, brings down Rashi that even that is usher. What is the reason for this prohibition? So Rashi and the Rambam each have their own two great Rishonim. Each of them have their own formulation, similar ideas but a little bit different, of what this prohibition is. Rashi says that it's yikar yirasam, it's giving weight and giving chashivas, giving importance to a different system, to the system of the idolaters, to it is displaying that their system of law is yakar, is precious, is chashuv. Instead of going to use the Torah law. And therefore Rashi says it's a chilul Hashem. The issue is that it's a chilul Hashem to go to a civil court instead of going to a Jewish court, a beis din, because that's a chilul Hashem. The Rambam has a lashon that, and this is how it's brought in Shulchan Aruch and Siman Chavav. The Rambam says it's kaharamos yad b'Toras Moshe Rabbeinu olav Hashem. It's like a person is rising his hand against the. So after that, the Rambam says that very, very strong words. In fact, the Rambam, especially the Shulchan Aruch, these are svarim, these are books that are of law that are generally not coming to say Musar type things, generally not coming to give titles and things like that. It's very uncommon to get that. And this particular halacha, they say a very strong lashon, and this is what it says in Shulchan Aruch, and it comes from the Rambam. Very strong. It says a person who goes to a civil court, and I just want to say at the beginning, we're going to talk about try to get to the details of what are the exceptions, when is it permitted, when is it not permitted, etc. But just to know when it is not permitted, the Shulchan Aruch says that Hareza Rasha, a person who goes, he's a Rasha. He's a Rasha, he's considered a wicked person for going. He has the status of a Rasha, ki'ilu chiref v'gidev. It's as if he went and was basically cursed and was blasphemized the Torah, and Heirim Yad b'Torahs Moshe Rabbeinu. That's the lashon of the Rambam and the Shulchan Aruch. A very, very strong lashon that you don't find really something similar. And that's the way that they understand it. So the basic idea, I guess the common denominator, is that God gave us a divine system of law, a full system of law that goes through all the details of all different types of monetary matters that come up. And we understand that is the greatest system of law. We're supposed to understand that's the greatest system of law. That is a divine law system, and nothing compares to it. And we should therefore be only interested in dealing with our cases according to the monetary law system that God created, or his chacham, his sages created, and not another system. That is the basic understanding of this prohibition. Now that means that let's start with two Jews. Keep the case simple, right? There you for sure have the problem. Let's say both the plaintiff and the defendant are both Jewish, and they make an agreement amongst each other. They say, right, one guy's not forcing the other guy into secular court. They make an agreement. They both want to go to civil court. They both prefer, wherever they are, the American justice system. They prefer that system, and they agree. They both would rather do that. So it says, it's brought down based on the rationale. It follows, right, that even if they both agree, it's usher. Because it's not just a question of a monetary issue, it's regarding monetary issues, but the reason for the prohibition is not just monetary. It's not that we're concerned that someone's going to end up with money that's not theirs. For that, in monetary matters, you could generally have a tanai shebamamun. People could agree. People could be moichel. There's mechila that works, right? If it was just for the monetary issue, there's another issue, is that it's a chil Hashem, right? This has a problem, right? I guess we could explain it this way. It's not just a problem between man and his friend. It's a problem between man and God. It's bein adam l'makom. A person, even the two litigants decide together that what they're going to do is go to a civil court. That is showing that they prefer the justice system of whatever civil court they're deciding to go to over the God-given divine law system that the Torah sets forth for us. And therefore, it applies even if they agree, even if they make a contract that they are both committing themselves to the din of the secular court. It's invalid. Now, more than that, the Rush says a fascinating thing. I believe this is the basic thing that's done when such a contract is made, is that we reinterpret the contract, that it just means to say that first they'll go to beis din, and if everything doesn't work out in beis din, then they'll go to that court. If they have some type of stipulation in their contract that if there's an issue, they'll go to whatever secular court it is, it's interpreted to mean as a backup plan, men hastam, even though they didn't really mean that, because that's what the halacha dictates. Now the question is, one of the question comes up is, what if you would have a court that is a Jewish court? The judges are Jewish. They just don't run with Jewish law. They don't run based on Jewish law. They don't judge based on Jewish law. What would be in such a case? Now, it might not be such a far-fetched case, right?
Depends where.
It depends where.
In Israel?
If you live in Israel, so there's a court system.
That's the case, right? I mean,
that is the case. There's a court system. There's a secular court system that is based on their own set of rules, that was based on their own moral beliefs, that has nothing to do with the system that was set up by the Torah. It has nothing to do with Choshen Mishpat. So the question is, does that help? Now, the first thing is the Ramban al Torah. The Ramban makes a very interesting point. The Ramban says that even though both the transgression of going in front of hadyotos, commoners, non-chachamim, and the prohibition of going in front of arkaos, in front of a non-Jewish beis are learnt out from the same source. They're both learnt out from Lifneim. There is a fundamental difference between them. This is what the Ramban says, and this is also said by the Tashbetz and Bron Shulchan Aruch here in Siman Chaf Vav, that when it comes to going in front of a non-expert Jewish beis din, says the Ramban, the parties could agree. If for whatever reason they're comfortable going to the non-mumchin, going to the non-experts, going to commoners, and that's how where they want their case to be judged. That's who they want to judge their case. They can make such an agreement, and it will work.
Like here.
Very good. So what I'm saying, some places there are no local beis din. Now nowadays with communication and travel, we'll try to get to this, but that's not going to be a very common issue.
Go to like Chicago or Detroit or Cleveland.
Right.
Yeah.
So the details would make a difference there, but if you don't have a beis din that's available, the Rashba says that you should appoint, if you don't have qualified, then appoint the non-qualified. The Rashba says in a tshuva, and they do their best. And if the dayan, if the and even in the case where there are more experts, if the litigants agree, if the bali dinim agree that they're going to accept the ruling of this court, who's a person who's not an expert but he's going to do his best, the Ramban says that is okay. However, like we just mentioned before, if the bali dinim agree to go to a secular court, then that is, even if they both agree, that is an isser, and that is an isser daraisa. That is a biblical prohibition of not going to their court, because over there, again, the rationale is that it's a chil Hashem. They're preferring a different source, a different system of law than Torah law. That is the isser of going to arkaos shalakum. Now, based on this, maybe we would say, well, what is the court system in Eretz Yisrael? Most of those judges, I don't know the details exactly, but I assume basically all of them are Jewish. So maybe I'll say, okay, so they might not know halacha, they might not know Jewish law, but maybe it should be like going in front of hedyotos, right? Hedyotos, if the two litigants agree, right, commoners, people that are not familiar with the halacha, if you go in front of them, then it's permitted. So maybe we should say that would be a heter to go to a secular court in Israel. However, the Chazon Ish and many others say that this is a very bad comparison. When we say that, when the Rambam and the Shulchan Aruch say that it's permitted to go to a beis of commoners, that just means the people are not so knowledgeable. But what are they trying to do? They're trying to judge according to Jewish law. They're not maybe the greatest chachamim, but that's what they're doing. They just might not be so accurate, right? When you go to a secular court in Israel, they have their own system of law, similar to the system of law anywhere else, similar to the American system of law. Not all the laws, but they have their own system of law, which they created based on a different set of values than the Torah system. Says the Chazon Ish, that is going to arkaos. That is the same thing as going to arkaos. It's arkaos shalakum. They happen to be Jewish, but they are judging cases based on a different system of law, and the person is doing the same thing, potentially even a worse thing. They are preferring a different system of law by people who should be using the Jewish system, should be using the Torah system. And the Chazon Ish says it's even worse. We'll try to get back to that when we discuss some of the heterim, some of the exceptions of when it's permitted to go to a civil court. We'll have to go back to and talk about the Israeli court a little bit more. Now, what if a person just wants to do mediation, right? They don't want their case to be judged based on a specific set of laws. They have an issue, partners have an issue, or this company has an issue with this client, or whatever it is, and everyone would like to come to a settlement, but they haven't been able to come up with it. It's very complex, and they figure, okay, this person, he's very smart, or this, this group is they have a good sense of business. They have a good sense of this business. They'll help us make a settlement, and we'll make it. Maybe they could help us come to a compromise. So, is that considered a problem of not going to a non-Jewish court? So, the basic answer is that if a person just wants to do an informal mediation, right? Even if they want to go to a person, doesn't matter whether he's Jewish or not Jewish, doesn't matter. They're just informally, they're saying, we want to hire you to help us come to an agreement. We're not interested in having our case judged. We'd rather come to a pshara, we'd rather come to a compromise. look at the details of our case, help us come to a compromise. That would be permitted. Because they're not preferring a different system. They're not choosing a different system. They're choosing not to have their case judged, and they're not going to a court at all. They're not using a court system at all. However, for this to be done in an official court, to go to a court and have a mediation done through arkaos, that would still be a problem of arkaos, and that would not be allowed. Similarly, there are poskim that talk about that there are certain business practices that certain businesses at the minhag, the way that business works is that they kind of have their own system of how cases are dealt with. For example, the diamond industry or other such things, they have their own system where they're not really going to the regular court. They kind of have their own sets of rules, and they deal with it within that industry based on its own details of how it works. So there are poskim that say that also would not be a problem of going to arkaos shel akum, because it's really something which everyone kind of accepted from the beginning, that they're coming in and basically it's how the business works. It's a chiluk of how the business works. It's not going particular to arkaos shel akum. It's that the entire regular court system is substituted in such a case, and therefore it's not viewed as choosing the Goyish court system over a Jewish system. It's looked at as that industry has its own way of how it works. Now, what are some of the cases when? Well, one other question that we would have when going to. Right, let's talk about all the different parties involved a little bit. If a person is summoned by another Jew, one Jew is summoned by another Jew, unfortunately, to a secular court. Now, if he doesn't show up, then he's going to lose his money. He's going to get in trouble. So,
default judgment.
Sorry?
I think they call it default judgment. We're automatically
by not going, right. A similar issue would be what happens if a person summoned his defendant to beis din, and that person didn't show up. So they were summoned, and they didn't show up. Now, beis din in our time doesn't have the same authority that it did, in the days of yore, in the good old days, when Yad Yisrael Tekifa, when we were in control of our place. We're now in Golis, and we don't have, the beis din doesn't have the same capabilities that it did. It could judge on cases, but it cannot enforce it the way that it ideally a beis din would. So in these cases, let's start with the case of a person summoned someone else to din, and they didn't come. So the beis din, typically they'll do it 3 times. They'll give them 3 hazmanas, three summons to beis din, and the person just ignores it. They said, beis din, that's a joke, I'm not going. So the Gemara in Bava Kama has a very, very unclear Gemara. It's basically a line of the Gemara. It's not really very clear what it's saying at all. It says that, you try to work something out with someone, and hopefully it works out, and if it's not, basically go hard on them, throw the wall on them. And it's not really clear what the Gemara is saying. There's a tradition from the Gaonim, from Rav Palti Gaon, and this is brought down in the Rush, and this is brought down in Shulchan Aruch, that what the Gemara means to say is if a person is evading a din in beis din, that if a person is summoning someone to beis din because they are owed money or whatever their claim is, and they are being ignored, says Rav Palti Gaon, the Gemara is alluding to a din that they are allowed to use the civil court in order to get their money. Now, the question is, as the Kli Chemda talks about this, what exactly is the heter over here? Typically, if you have something which is usser, which is prohibited, especially if it's something which the violation of it is by actively doing something, right? Bekum ba'aseh. Generally, there's no such heter like, oh, but you need to get your money. It's pasuk in Shulchan Aruch that a person has to give up on all their money in order to not transgress on a negative commandment. So the Kli Chemda is bothered, like, what is this heter? Like, why? What is the reason why? We see that the Gaonim are saying that this is what the Gemara is telling us, but why would it be? So possibly, many suggest that the basic understanding is that if Chazal understood that when the reason doesn't apply, when the reason of not going to arkaos shel akam doesn't apply, that can create a heter. So if you think about the case, this person is trying to get his money. He has a claim on another person. That litigant is avoiding going to beis din. He has no way to get his money. So when he then goes to the civil court system as basically as his last recourse of how he could get his money back, that is clear that is not because he is preferring that system, that he's preferring that law system to the Jewish law system, to the Torah law system. Rather, it's that he has no other way of getting his money. Unfortunately, the way that we are living in our goals, the regular Jewish law system, the regular Torah law system, is not able to enforce its laws. And therefore, it's clear that he's not going because he prefers that system. He's going because he's got no other choice. Therefore, it is permitted. The arkaos